Hello, everyone. Welcome to the Business of Spying, Litigating Against Surveillance. Thank you so much for your patience as we got the small technical difficulties sorted out. So my name is Hawley Johnson, and I'm the Associate Director of Colombia Global Freedom of Expression, and I'm going to be moderating this panel today. We're bringing together David Greene, Civil Liberties Director at Electronic Frontier Foundation, Sarah McKune, Surveillance Strategic Litigation Project Lead at Amnesty Tech, and Gil Gan-Mor, Director of Civil and Social Rights Units at the Association for Civil Rights in Israel, to discuss litigation efforts against unlawful targeted surveillance. So the way we'd like this to flow is I'm just going to give a few quick points and overview over some of the issues, and then the speakers will have an opportunity to discuss efforts their organizations have taken and share their perspectives. During the conversation, please post any comments or questions for the panel. My colleague Bach is going to be moderating the chat, and he will summarize and then pose questions to the audience as we move through the discussion. So as we're all aware, the dangers of unlawful surveillance are well known. In his 2019 report, UN Special Rapporteur David Kaye wrote that targeted surveillance, particularly of journalists, political opponents, and human rights defenders, has been repeatedly shown to lead to self-censorship, arbitrary detention, sometimes to torture, and possibly even to extrajudicial killings, which may have ultimately been the case in Jamal Khashoggi. In 2013 and 2016, the General Assembly passed resolutions condemning unlawful or arbitrary surveillance as highly intrusive acts that interfere with fundamental human rights. Yet the problems of surveillance persist. You've all heard that NSO's surveillance technology was allegedly used to target 1,400 mobile devices belonging to politicians, journalists, and human rights activists. In fact, a staff member of Amnesty International was one of the individuals targeted. And Sarah McKune will speak more on Amnesty International's litigation efforts against NSO and the challenges it has faced. States recently have also turned to surveillance as part of their COVID-19 response. And Gil Gan-Mor is going to tell us about his organization's litigation efforts against the Israeli government to ensure that checks and balances on Israel's rapidly expanding surveillance state. David, importantly, in his report, also recognized that litigation can play a key role in stemming abuse from surveillance. However, he observed that there's a lot of barriers to successful litigation, and formal complaints are significant. So some of the barriers he noted are the lack of judicial oversight, lack of remedies, causes of action, enforcement, and data protection. Alleged victims have commenced litigation or formal complaints against private surveillance companies or governments in at least 8 countries with mixed to weak results. So at this time, I'd like to pass the floor to David Greene. Is he with us right now? I'm not seeing him. So Sarah, would you mind jumping in? Could we start with you?
Sure, I'd be happy to. Hi, everyone. Can you hear me?
Yes.
Hi, I'm Sarah McKune. I'm the Strategic Litigation Surveillance Project Lead at Amnesty Tech. And I'd like to start just giving some background concerning the administrative action that was brought in Israel concerning the export license that was granted to NSO Group to export its technology, the Pegasus software, and related components that have enabled surveillance against human rights defenders. This was an action that was brought by a number of petitioners in Israel, and it was supported by Amnesty International, including through the submission of an affidavit to the court outlining some of the findings, the technical findings of the targeting of an Amnesty staffer and other related research. The research has been going on for many years by various civil society groups, including Citizen Lab, Amnesty, Access Now. A number of civil society groups and individual researchers have come together to try to track the use of this type of technology against civil society groups and human rights defenders. And so we had been aware that it had been going on for many years, that NSO was one of the companies actively marketing and selling this type of software. to states with serious track records of human rights abuse and inappropriate surveillance that undermined internationally recognized human rights. So in the summer of 2018, an Amnesty staffer was actually targeted with a text message that was linked back to. After that point, the petitioners in Israel mobilized. Amnesty International sought to support the effort to seek revocation of the export license granted to Nso for the purpose of exporting the system used against Amnesty International specifically, and used to violate human rights at large. And the judgment was issued in this case last month after an extended period in which the district court in Tel Aviv held hearings to discuss the matter and reviewed the submissions. The judgment this month actually rejected the petition, which was disappointing but not unexpected considering the larger stakes at play here. And the judgment highlighted a number of rationales for the rejection of the petition. One was that the process utilized by the Ministry of Defense in licensing technology such as that provided by NSO was appropriate, and that the Ministry of Defense engaged in ongoing strict control and monitoring of how the technology was being deployed, even after the point of licensing. So that was one of the items that they raised as convincing the court that the process was appropriate. The court noted that the Defense Export Control Authority at MOD exhibits special care and attention towards issues of human rights violations. The court also noted that they felt there was insufficient evidence brought to establish the surveillance of human rights defenders had taken place, and that NSO Group itself was involved. And so those were sort of the main points of the judgment, which was itself very succinct, very short, and ultimately, as I noted, not particularly surprising. But I think this judgment and the process of bringing the case to the court, and some of the challenges involved in that, really highlight a few things which I want to flag here. One is the challenges associated with the lack of transparency in this industry. The court noted that they felt there was insufficient evidence brought, but that raises the question, well, how do you find an amount of evidence that is sufficient when you're talking about an industry that is completely opaque and that governments allow to remain opaque? There's very little information publicly reported about what the capabilities of these technologies are, where exports are made, what the licensing process actually involves in terms of the human rights considerations assessed, and which licenses are actually granted, which ones are denied. So the lack of transparency is a real problem, and it can manifest itself as problems for litigants, and in the administrative action, it was a real problem in terms of establishing, well, which license would we actually seek to revoke, and could we establish that a targeting and surveillance actually occurred. Another transparency issue that we encountered in the Israeli action was the use of gag orders. The Ministry of Defense requested a gag order, and it was the gag order was allowed, was permitted by the court, which resulted in closed door hearings. And it wasn't until the judgment was issued that the gag order was lifted. Unfortunately, the judgment itself is not subject to that gag order, so it is something that can be discussed and learned from here. But on the whole, what we see is that the Ministry of Defense is rather insulated from public accountability, and that applies to the company that works with Ministry of Defense as well, in this case, NSO Group. It's also problematic in the export control context to bring an action for remedy, because there is significant deference to the executive branch when it comes to export control and to the actual administrative organs that are conducting the licensing process. And that was an issue that was raised throughout the action. The court recognized the broad authority of the Defense Export Control Authority and noted that when it comes to issues involving significant political considerations, national security, and foreign relations, this organ should be given wide latitude to conduct the licensing as it sees fit. At the same time, the export system did not have an emphasis on human rights as one of its objectives. And NSO actually raised that issue in its pleadings, that human rights is not one of the purposes of the export control law. And while human rights may be factored in and balanced, it's not necessarily determinative for the outcome of the licensing process. So that's some of the issues that we encountered in the administrative action to revoke the export license. And there's a number of other points that I think would be important to raise when discussing the potential for litigation, but perhaps we should wait till a little later in the session to get into that.
Just one quick question. Is this the end of the road for you guys on this case? Is there anything else that you can do, or do you know of any other cases that are currently in process that are dealing with any of these issues?
Well, it's still under discussion. The Amnesty section in Israel and the petitioners in Israel who brought the case are still assessing the judgment. Amnesty International, in supporting that work, is assessing as well, and it's still to be decided what next steps will be taken. But I think it's not surprising that the case turned out the way it did, and we'll see. What we determine the appropriate next steps to be.
Excellent. Thank you so much, Sarah. Because we're a little short on time, I'm going to move right on to David. Sorry, David, we didn't mean to overlook you, but we couldn't find you for that brief moment. So I'm glad you're back. Glad we found you. And so now I'm going to turn the floor to you. And EFF has been working on curtailing mass surveillance through litigation for many years. So could you explain, in your experience, what are states doing, and are they doing enough to limit abuses from surveillance, be it mass or targeted? And what role does litigation play in this context?
Well, I don't think they're doing enough. I guess I should introduce myself. I'm David Greene. I'm the Civil Liberties Director and a Senior Staff Attorney at EFF. I've only been at EFF for 7 years, which means that our mass surveillance litigation has been going on since well before I joined EFF. We first started litigating against mass surveillance in 2006. So And so I generally don't think states are doing enough, and it's not, in some ways I do think there are some aspects in which they try, but I think there's this really what we see in the U.S. certainly is this interesting dynamic whereby states express some concern for civil liberties and for human rights. They're completely secondary to what they consider to be either their national security needs or domestic law enforcement needs for the information. And they do, to some extent, put laws and procedures out there and then rely on civil society to test the constitutionality of these procedures because they don't have an internal process for assessing the legality of they can come up with their rationalizations, but they don't have a built-in adversarial process where they can test whether a procedure is legal. And in some ways, they really rely on civil society, first during a legislative debate, if there is one, and then through litigation to do it. Where we get stuck, though, is, especially in the US law, is that it's very, very difficult to find a plaintiff who has standing to actually challenge the legality of these laws. in the legality of these procedures, whether they're either are legal with respect to their statutory authorization or whether they are constitutionally defect. And this is really what we've seen in our litigation over U.S. mass surveillance, again, since 2006. So I think at almost every RightsCon, someone from EFF has talked about this litigation, so I won't go into in too much detail, but basically in 2006, EFF, through a whistleblower, learned that the US government was tapping into the hubs where the fiber optic traffic flowed, one of which was in San Francisco, quite close to our office. And essentially, what we learned was they were essentially making a copy of all fiber optic traffic, all internet traffic that flowed through these communications hubs, and then going through that, searching through that for information. In 2006, we brought a lawsuit against AT&T, not the U.S. government, for doing this, and ultimately, the U.S. Congress granted AT&T and the other telecommunications providers immunity from such lawsuits. So in 2008, we started over again, and we filed the lawsuit that is still ongoing now, called Jewel versus NSA, and that case mostly challenged two main mass surveillance operations. One was the use of the fiber optic splitter, the surveillance of all internet traffic going through major communications hubs. And the second was challenging the mass collection of call detail records, which became then the subject years later of sort of the very first sort of Snowden revelation. And we've been challenging these ever since. And the sad sob story about this is that we've learned very little about the merits, the legal merits of either of these procedures, because what the U.S. government has done at every turn is put up procedural obstacles to an adjudication of the merits of that. And the two main ones that we're still fighting over now are standing. Under U.S. law, federal courts in the U.S. Can only adjudicate claims we call cases in controversy. Someone actually has to show that they were actually harmed by the governmental action. And U.S. courts so far have not found it enough to say that just because something is mass surveillance, where everybody is surveilled, that gives every single person standing. They really are looking for people very individually to show some proof that they have actually been surveilled. We have tried to do this in the Jewel case. By all the plaintiffs are AT&T customers, or were at one time AT&T customers, and to show that because all AT&T customers were surveilled, they should have standing. But that hasn't been. This has still been an obstacle with the courts, and that ties into the second procedural obstacle, which is what in the U.S. is known as the state secret doctrine, whereby some cases are just considered to be non-adjudicable because the adjudication of them would require the government to reveal important state secrets. And this is really the same things that we're fighting over now. So we're caught in this impossible situation where we say, well, they're AT&T customers. We know that AT&T did this to all their customers, and they say, well, you can't prove that they did to all their customers. You just have a whistleblower, and you don't know exactly what happened. And then we actually can't tell you what happened because it's a state secret. So we've been caught in that trap for quite a bit. We've been sort of up and down the court system for a while. We're currently now back at the appellate court level. And the main challenge now is Congress, in actually passing the 2008 law, the FISA Amendments Act, actually created a procedure to avoid this very thing happening. They created a procedure where courts could accept and review secret evidence. This would be a one-sided procedure. We, as the plaintiff's lawyers, wouldn't get to see it, but at least the court would get to accept secret evidence, and it would, and because of this, it would make the issue adjudicable, that the adjudication could not be stopped via the state secrets privilege. But that didn't happen in our case. Our trial court judge did accept a lot of secret evidence, but still found the case to be non-adjudicable, and still found that he couldn't reach a decision on the merits. And so, 12 years later, we're now back up at the appellate court to decide whether we actually are deserving of some decision on the merits. Now, so that's of course greatly frustrating whenever I see decisions out of Germany or the UK where they get decisions on the merits regarding mass surveillance. Okay. First, we call and congratulate our friends working on those cases, and we get very jealous. There have been many victories along the way, and so in the course of 12 years litigation, the case is still live because there have been some small victories along the way. But still, it's a long time to go without a decision on the merits, and especially when you talk to people in the government who say they actually really rely on this type of litigation to make sure they are doing the right thing. So that those are the obstacles we face in the U.S. legal system. It's with target surveillance. It's a little different, but we really tend to be limited in that case. The only people who usually are able to prove that they were the object of target surveillance are those who find out in the course of defending, if they've been charged with a crime, and then the government is required to reveal how the evidence against them was gathered, and that might reveal that they were subject to either mass or targeted surveillance, and they can challenge that. So that tends to be the main place in the U.S. court system where legal challenges are made to more targeted surveillance systems, is by criminal defendants. And again, there's many obstacles though to that actually, to that actually being a good venue for adjudicating those issues.
Great, thank you so much. It sounds like this lack of evidence, this lack of transparency is really hard to penetrate in order to get the information to the courts in order to bring these forward. So hearing that in both from what you said and Sarah said, and again, because of our time constraints, I think it's a good time. We'll move on to Gil. And we're at a historic moment now brought about by COVID-19. States around the world instinctively have jumped to surveillance technologies to track the spread of the virus. And the Association for Civil Rights in Israel took on the Israeli state to demand transparency and limitations on the government's free rein to deploy mass surveillance on the Israeli public. So, Gil, could you please tell us about your case, how it came about, how you challenged the misuse of the surveillance, and what the main challenges you faced were?
Yes, thank you very much. So at the beginning of March, the pandemic hit Israel. And as the number of cases increased, the government searched for quick, effective tool to know the location of those infected in the days prior to the diagnosis, and also to track close contact between those infected and others. So the government said that they were unsatisfied with any civil tool. They were looking for different tools from private companies. And eventually they landed on the Shin Bet, the General Security Agency of Israel, which is a secret agency. The agency roles are to protect the country and the democratic regime from security threats, such as terrorism, espionage, and other national security threats. For that, the agency received by law tools that designed to be used for terrorism, to stop terrorism. And as we now know, one of those tools is operating a vast database with communication data that received from the cellular companies in Israel. And in this database, they have information about everyone, not just people who are suspect of terrorism or anything like that, but on everyone in the nation and all the time. So as far as we know, the database includes very, very sensitive and private information, such as locations, contacts, who did we call to, even the credit card that we used to pay for the phone, and so on. So the only thing that is not allowed for the Shin Bet is the content of conversation. So digging for information from this database is done only with the only with the approval of the head of the Shin Bet, with very little oversight, zero transparency, and there is no need of search warrants from the courts. So now I think you can understand why the use of the Shin Bet capabilities was considered the perfect choice for the government fighting the pandemic. The only problem is, as I mentioned before, is that the law regulates the agency, the Shin Bet, allows it to use those mass surveillance capabilities for national security threats. So how could it be used for civil crisis like the COVID-19 pandemic? So here is the first act of the play, the first out of three. The first act of the play, at the beginning, the mid-March, the government passed an emergency regulation authorizing the Shin Bet to use its mass surveillance capabilities to track the location and routes of persons infected with COVID-19 and anyone who was in close contact with them. And here it's important to understand the background. I said it's emergency regulation. So in Israel, there is still a formal state of emergency that exists since the establishment of the states in 1948, which is a very problematic situation to begin with. So because we have a formal state of emergency, the government has power to publish emergency regulations that can temporarily change any law. And they can do that to deal with imminent threats unless the parliament can operate despite the emergency situation. But unluckily, the pandemic started in Israel during a period of a year with a caretaker government, with a political crisis. The prime minister is facing charges of corruption and about to go to trial. There was a newly elected Knesset, the Israeli parliament, that wasn't yet functioning. And in these circumstances, you can see and you can understand that we had a health crisis that found us in the middle of a political crisis. And on this background, the government, in the middle of the night, issued these regulations to authorize the Shin Bet to start tracking people. So we filed our first petition to the Israeli High Court of Justice, which is the Supreme Court in Israel. And this petition was heard very rapidly and resulted in an order that demanding Knesset oversight over this regulation in order to be able to continue using the Shin Bet. So this brings me to the second act of the play. Because using emergency regulation was blocked, the government decided to use a clause of the law regulating the Shin Bet, and this clause stated that the government can authorize the Shin Bet for additional role that is not one of his core roles, but it has to be connected to national security and to be approved by the subcommittee for intelligence in the Knesset. So in order to make it kosher, the Attorney General interpreted COVID-19 crisis as a national security issue. So the government went to the subcommittee and got their approval. And then we amended our petition. This was the second petition. We claimed that this was still illegal. And eventually our petition led to the ruling in the end of April that on the bottom line says that unless the Knesset passes special legislation, the Shin Bet tracking cannot continue. The court said that even if at the beginning of the situation, it could be handled like a national security threat, to continue with tracking, it can only be done with the primary legislation. And this brings me to the third act of the play these days. So a few weeks after the decision, the government decided to stop using the Shin Bet, but a few weeks later, the second wave started in Israel. And quickly, the government renewed the legislative process and passed a law authorizing the Shin Bet tracking for 6 months with parliamentary oversight. After only 2 weeks of using the capabilities of the Shin Bet, there were more than 150,000 people that received quarantine orders based on the tool. The orders are sent by SMS by the Ministry of Health. So a lot of people got SMS to start home quarantine. And it was a huge public debate, not only about privacy, but also about the accuracy of the tool and about the infringement of liberty, because many people felt that the tool had too many errors and the quarantine orders were unjust. In fact, only 4% of the people that were quarantined by the tool was eventually found positive. And the effectivity of the tool to stop new infections is questionable. For example, we now understand that the tool does not know if you were at the same floor, 2 meters or 8 meters from the person that has COVID-19, if you wore a mask or not. So maybe it might be good as an indication, but not as a tool to trace close contacts. Many people try to appeal the decision unsuccessfully. In those 2 weeks, we saw that public trust in the health authorities fell by 20%, according to a recent poll. And people were also very worried to receive that SMS, especially with the current economic crisis. People were afraid to not be able to go to work. Some started leaving their phones at home. People are also concerned that the tool will be used to quarantine anti-government protesters, and we have a lot of protesters these days against the government. So we can actually see, like on live happening now, the chilling effect of the surveillance. So we are now working on the third petition, bringing it to the court next week. And we hope that this time the court will put an end to this practice.
Have the arguments changed for this third petition now that there's this revelation that the app is highly inaccurate? Have you taken a different tact in your strategy?
I think yes. I think we emphasize it more now. This argument was not in our core arguments at the beginning, but now obviously we have more information, and this is something that is very important for the balance between the effectivity and the damage that this tool has. But basically our main arguments did not change. We claim that the pandemic is a serious civil crisis, but has nothing to do with national security. That the Shin Bet was granted these enormous mass surveillance capabilities to fight terror, not to track innocent civilians, and that this is a slippery slope. Using Shin Bet for health crisis is a very dangerous precedent. We also claim that it's not temporary at all. The government is planning to use it for a long time, so basically it's normalizing mass surveillance tools for a long time. And there is alternative, such as the Shield app, which in these days the government launched the second edition of the app. The Shield app is voluntarily downloaded, needs a consent from the people that are using it, and the data is only kept in the phone and not transferred to the government without the consent of the users. So we also claim that there is other alternatives, not technological alternatives. For example, increasing the ability to use human contact tracers. In Israel, we have only 300 contact tracers, which is 1 to 30,000 people, which is very little compared to other countries. And eventually, we also, using the fact that no other democratic country use its secret security agency to stop the spread of the virus. So we asked the court to make sure that Israel will not be the only democratic country that use such an extreme tool, and will put the effort to use alternative tools that can also keep the right to privacy and liberty, and also fight the spread of the virus.
Great. Thank you so much, Gil. It's fascinating, and good luck with this next round. I hope you have enough public support to get the courts to pay a little bit more attention to the issues. So we're getting down to our last 15 minutes, and we're going to try to take a few audience questions at this point. I think, Bach, you had one regarding the other big case that's in the news.
Yeah, thanks, Hawley. One of the comments in the discussion was to talk about the big case, the WhatsApp or Facebook versus the Nso case. And just so to those who are not familiar, it's when the Facebook brought a lawsuit against the Nso, the company that sells hacking tools. And they're arguing that the malware that Nso developed and sold to the governments of Saudi Arabia, Bahrain, and Mexico, and a few others have been used to target users of WhatsApp, who included opposition leaders, journalists, and human rights defenders all around the world. And I want to take this opportunity to kind of ask a personal question: is whether or not you think that Facebook's response to NSO's actions represents a turning point in how tech companies respond to the misuse of lawful hacking tools. Because in a way, a lot of this surveillance technology is aimed at the tech we all have on our computers and our phones. So here we have a major social media company challenging the fact that they're being targeted and that their product is being undermined and its safety is being undermined. And not just by bringing laws to it, but also, what Facebook also interestingly did is that it notified the targets of the hacking, which I think is kind of unique, because here we have a company directly telling users saying, well, you have been harmed. So maybe it resolves those questions of standing and proving harm. So I guess the question is, do you think it's a case that represents a turning point in the way litigation may go forward in the future?
Well, I hope so. It is really noteworthy. And I do think this is one of those areas where WhatsApp deserves a lot of credit for doing this. And under US law, we at EFF, and I think a lot of folks have taken exception to a way a lot of the sort of dominant companies have litigated under the Computer Fraud and Abuse Act, which is the federal anti-hacking law in the US. And that law has been used by the companies really, for sort of solely economic interests in the past, and in a way that we've found to be sort of way too expansive. That really has really to try to stop a lot of important security research, and even sort of non-hacking and non-harmful attempts to make an interactivity. So I think it's really important that they are doing this, that they are doing this in a way that seems to be directly serving their users, and also using the law in a way that I think it really was intended to be used to protect the security of their own system in a way that is protective in this use of their users. And I do hope that we will see more challenges like this going forward.
Yeah, and if I could add a few points to that as well, I think the WhatsApp case is very promising for future accountability of spyware companies. The motion to dismiss that has recently been decided on came out favorably for WhatsApp. The court rejected NSO groups claim concerning derivative sovereign immunity. They found that personal jurisdiction exists. They found that most of the causes of action could proceed, and they are now allowing discovery to proceed. But I think it's still important to recognize that the case has a long way to go, and it is very political. And I'm sure as discovery begins and continues, I'm sure there will be a lot of pushback, not only from NSO Group, but probably also from the Israeli government, because this is a case that deals with the sale, the export of sensitive technologies to foreign governments. And so it'll be interesting to see how those issues are sort of addressed in the discovery process. But I think it's great that the company brought the case. My one concern that I want to flag is that I think the significance of litigation as an avenue for remedy here really lies in the ability of individuals, or should lie in the ability of individuals, to bring causes of action on their own behalf, without having to wait for a government to step up and defend them, or a company to step up and defend them. And I think we do have a lot of work to do to make litigation more accessible to individuals so that they can do that. Number one, allowing individuals to create deterrence to this kind of activity, and number two, allowing them to access remedy. So I think if we're really going to get serious about litigation, we have to look at the supporting elements to that. Making legal action and evidence gathering more simplified, mandating certain transparency requirements such that more evidence is out there in the public. Coming up with creative approaches to costs and evidence preservation and access to technical expertise, and also looking at new forms of legislation that could make causes of action specific to this type of problem. And so we're not necessarily having to adapt or work on the basis of legislation that never contemplated this type of extraterritorial or domestic activity, this type of intrusive surveillance being used against individuals. So I'd like to definitely emphasize the need for more work on legislation in many, many different countries.
That's great. Thank you so much. I guess we could move on to one final question. Bach, do you have anything else that from the audience that you should
No.
forward? Okay. So one of the questions that we were thinking about is, the proliferation of surveillance technology was brought about and justified as part of the war on terror and the never-ending state of emergency that came with that. But now the pandemic has brought about yet another layer to the state of emergency. So, where are we now with this expansive use of surveillance and these incredible justifications for national security concerns? So, and where do we go from here? Do you guys have any inputs on where you think litigation can go in this climate, this very, very difficult climate?
I think it'll be interesting to see what happens with legal challenges to COVID-related surveillance, digital efforts at contact tracing. It's a little different in the U.S. because we don't have any type of centralized response to COVID from our federal government at all. And so this is where we really are seeing this play out is at the state and local level. And I think what we're really going to see some interesting action is really on areas like universities and employers that are going to require students and other members of the university community and employees to install some type of very invasive app on their phone or something that's going to track all of their location, all of their interactions, and also in a way that is not going to be, because these are not institutions that are going to be as careful because I really haven't had to with this level of information before. With this type of private information. So my prediction in the US is that's where we're going to see litigation. I think we're going to see challenges to compelled uses like that, probably before we see challenges to governmental uses.
Well, I might add a few sentences. I think that one thing that we told the court in our case in Israel is that for many years we have experience in balancing between security interests and human rights, and we do that all the time in many cases, and the court knows how to do it, and also the authorities knows that they should always balance between the security interest and human rights. And now with the health crisis, I think we have to learn again from the beginning how to balance between those two. And in a way, we see that at least in Israel, and at least at the beginning of the crisis, there was very little balancing, and the Ministry of Health just, took anything that he could do, anything that he could do. And on this background, we saw many initiatives that are very alarming for privacy, and the fact that the public is also concerned and afraid, and there's so many things going on, is very difficult for us to understand what's going on and fight it and stop it, or force the government to do this balance that is so needed. And we also know that also in regular times, sometimes we see that the technology is already widespread before we have a public debate about it. So the first way the technology is introduced, and we see it on the ground, and then only then we start having the conversation about the limit of the technology. And now with the pandemic and the crisis, this process is even more severe. I mean, we see so many initiatives starting, and there's very little public discourse about those new technologies that are introduced to fight the pandemic, but obviously will stay much longer after the pandemic is over.
Thank you so much, Gil. So we're down to our last few minutes. Is there anything that anybody would like to add? Anything we've missed? Anything super important that people should be thinking about in this next phase?
I do want to, if just with regards to the COVID-related surveillance, I do want to recommend to folks who are interested. EFF has we have a whole section of our website right now devoted to COVID-related issues, and there's a lot. There's a lot of post analysis both by our lawyers and our technologists regarding contact tracing applications, and really looking into this the balance that Gil was talking about, where recognizing that there's potentially an important use for these types of things, but how do you do this within a human rights framework and in a way that's also technologically sound as well? And so there's a lot of writing there by people who've been looking at this more closely than I have individually. And so I refer folks to that. If you even just search for EFF and COVID, you'll get a landing page that will link you to many posts in this area.
Yes, I'd also like to flag a couple other pieces that should be considered as part of the surveillance litigation and strategic effort. One being, it will be important to try to continue to push governments to discuss their own obligations with respect to private companies entering into this space. What are government obligations in terms of transparency requirements, export requirements? That's a given, but even beyond that, what kinds of incentive structures are governments creating for companies operating in this space? Should governments be establishing codes of conduct for contractors who would wish to work with them, that recognize human rights law. And then on the other side, also the investment component. It's important to continue to follow. Francisco Partners was the private equity firm that was first invested in NSO Group. Now it's Noble Pina. And their role, not only in providing the resources to these companies to engage in this market and provide these kinds of tools, but also in guiding the company's decisions and strategy, needs to be closely examined and included in consideration of, accountability efforts and potential for redress.
Thank you so much. We are down to our last minute. They're going to pull the plug on us in any moment. So before they do, just thank you all very, very much for making the time and coming to have this very important discussion. And as a personal appeal, I'm hoping you will send us all your court documents so that we can analyze them and put them into our database. And we'd be happy to put updates on these cases also on our website and put them through our newsletter as well. So again, thank you all very, very much for your time.